I'm Linda Greene, professor at the University of Wisconsin Law School, and thank you so much for coming to the program. Before I formally introduce the program and introduce the panelists, I have an assignment. Let me follow through. Welcome to the 2015 AALS Annual Meeting Program, Beyond Michael Brown and Ferguson, Effective Responses to Police Force. A CLE attendance sign-up sheet for this session is located in the rear of the room. If you sign this sheet, the AALS will verify your attendance at this program for CLE purposes. Please refer to the sign-up sheet for more details. In addition, we value your feedback. Please take a moment and complete the session evaluation that you were handed when you walked into the room and leave it with the student at the door. So those are my required announcements. I'm Professor Linda Greene of the University of Wisconsin and the convener of this panel, Beyond Michael Brown and Ferguson, Effective Responses to Police Deadly Force. I am so pleased to see so many of my colleagues here. I want to thank the Bridge Programs Committee for the opportunity to discuss this very important subject that has galvanized America, indeed the world, across the board. I must acknowledge the presence and support of our Executive Director, Judith Arene, and the AALS staff in the production of this panel. We also have a special guest with us, the Honorable Richard Roberts, Chief Judge of the United States District Court of the District of Columbia, and who is also the former Chief of the Criminal Section of the Civil Rights Division. Thank you, Judge Roberts, for your presence. It's an honor to have you here. I am so sorry that I was unable to accommodate all who wish to be a part of this panel. There will be many other opportunities here at the AALS, and I also will welcome your participation during our commentary period and the Q&A. And I also trust that you will continue this discussion during the entire conference and also in formal and informal conversations. What's most important, of course, is that we continue this discussion at home, at our law school, and in our communities. I'm really excited to introduce our panelists. They are right to left. Professor José Anderson, you can raise your hand, and we've got beautiful name cards there. Mr. John Burris of the John Burris Law Firm, and that was Professor José Anderson of the University of Baltimore School of Law. Professor Paul Butler of Georgetown University Law Center. Devon Carbado of the University of California, Los Angeles School of Law. Professor Sharon Davies, who is a professor at Ohio State University and also the director of the Curran Institute for the Study of Race and Ethnicity. Dean Jeremy Levitt, Dean of Law and Vice Chancellor's Chair, University of New Brunswick. The Honorable Cruz Reynoso, former Justice, California Supreme Court, and also was awarded the Presidential Medal of Freedom by President Clinton, a great honor. Professor Song Richardson of the University of California Irvine School of Law. And last but not least, Professor Cami Chavis Simmons, Director of the Criminal Justice Program at Wake Forest University School of Law. We've divided the discussion of this vital topic into 3 parts, with each panelist speaking 5 minutes on their topics to start. In part 1, Professor Paul Butler will situate the phenomenon of police deadly force in the overall context of criminal law enforcement. Next, 3 panelists will address the causes of police use of deadly force against Black males. For that task, We have Professor Sharon Davies, Professor Song Richardson, and Professor Devon Carbado. The remaining panelists will discuss whether there are effective remedies to prevent or redress the use of deadly force. Those panelists will include Professor José Anderson, Justice Reynoso, Professor Simmons, Mr. Burris, and Dean Levitt. These panelists will focus on remedies. We'll have a few questions to the panelists on whether the remedies proposed are equal to the problem of police deadly force, and then I want to be sure to involve the audience with both comments and questions. So I'd like to start then with Professor Paul Butler, who will share with us his contextual framework for understanding this problem. Thank you, Paul.
Understanding Ferguson and the law, and I'm going to be very negative. Most of the recent scholarship and discourse on race and crime is focused on over-enforcement of law and African Americans. So if you think about the familiar critiques of the war on drugs, stop and frisk, broken windows, they all have to do with the selective application of criminal law to black people. So think about some of the troubling statistics. Blacks are about 12% of people who use and sell drugs, but we're about 60% of people who are locked up for that crime. Think about the famous factoid from the new Jim Crow. There are more blacks under criminal justice supervision now than there were slaves in 1850. All of those suggest that less attention from police and prosecutors would be a good thing for blacks. But the cases that we're focused on today reveal a different race and crime problem that's kind of the opposite of the first problem. Now, the issue a lot of people think is under-enforcement when the people who caused the deaths of Trayvon Martin and Michael Brown and Eric Garner go unpunished. The concern here is that blacks have been denied the equal protection of law. Historically, this has been the most salient race and crime issue. The NAACP was formed more than 100 years ago mainly to address the problem of white violence against African Americans and the failure of the law to punish those criminals. And indeed, the number of extra-legal trials and punishments of African Americans by white civilians has substantially decreased beginning in the 1930s. Now, we don't know exactly why this occurred, but we do know the law did not play a significant role. Some of the states where lynching was occurring had anti-lynching state laws at the same time that lynching was flourishing. And no federal anti-lynching law was passed until 1968, after the number of lynchings had gone way down. The Supreme Court looked at the issue of under-enforcement of law in McCluskey versus Ferguson. The court looked at statistics that suggested that when you're most likely to get the death penalty if you kill a white person, especially if you're a black who kills a white, you're least likely to get it if you kill you're least likely to get it if you kill a black person, especially if you're a white person who kills a black person. In other words, Mr. McCluskey's petition to the court was that black lives matter. The court's response was, well, actually they don't, at least not as much as white lives. Mr. McCluskey's claim was that the only reason he was being killed by the state was because he was black. It wasn't because of his crime, because a similarly situated white person wouldn't have been executed in that context. The court said that that was constitutional, and indeed, if Mr. McCluskey got the relief that he sought, that would undermine the entire criminal justice system. When we think about areas in which the law has been effective in combating race discrimination, I can only think of a few examples: the ban against interracial marriage, the Voting Rights Act, affirmative action. But I can think of many more examples where the law hasn't made things better, including in education, housing, employment. In criminal justice, it's a little different. In criminal justice, things have actually gotten worse. In the 1950s, disparities in incarceration, black-white, were about 2 to 1. Now they're about 7 to 1. What happened? Well, in some ways, the law replaced lynching. Trial and punishment of African Americans are no longer extra legal. Now they are legal. The law teaches us that what George Zimmerman did to Trayvon Martin was justified. that the killings of Michael Brown and Eric Garner are what you call police work. Now, this happened in part in response to the Supreme Court's project to expand police power. This project began after the last major time there were urban uprisings. That was in the 1960s. These urban uprisings were also mainly in response to excessive use of force by police. And what did the court do? It dramatically expanded police power. So the court decided these cases that said that the police can lie to you, they can run you off a cliff for the crime of speeding. If they see you in a high-crime neighborhood and think you're trying to avoid them, they can detain you even if they have no reason to suspect you of a crime. The police can arrest you and throw you in jail even if the crime that they're throwing you in jail for does not carry imprisonment. So what these cases enable was for the police to stop and kill Michael Brown for the crime of jaywalking, to stop and kill Eric Garner for the crime of selling unlicensed cigarettes in the street. So knowing what we know about the law and how it operates in favor of over-enforcement for African Americans and against under-enforcement for African Americans, we ought to be wary about some of the suggestions that in order to punish the killers of Trayvon Martin, Eric Garner, and Michael Brown, we ought to expand prosecutorial power. When we do that, that expansion of prosecutorial power and police power often comes back to bite us in our black behinds.
Thank you, Professor Butler. Professor Davis, you've argued that structural and cognitive lenses are helpful in understanding the vulnerability of black males to police deadly force. Please explain and elaborate.
Well, yeah, I just love following up on what Paul said because he really framed this beautifully for us. But I'm going to take this in a slightly different direction because the panel here is asked to talk about the police and police responses to black males in particular. And that's an important topic for us, obviously, today after the events in Ferguson and Staten Island, earlier in Sanford, Florida, and so on. But we make a mistake, I think, when we confine our understanding of what is going on in the country to a police problem. This is more than a police problem. This is an us problem. And what is happening with the police is an acute aspect of the problem in the country. But it is acute because we give the police certain authorities to act on our behalf. So we give them the authority to walk around with guns and to discharge those guns on our behalves. But what is happening in the minds of the police is actually no different than what is happening in the minds of non-police when it comes to, in particular, black males. And I want to say that first because we need to think about the many occasions when the police are responding to scenarios at the calls of civilians. And so let me just give you a couple of quick examples of that. We know that in the recent shooting of 12-year-old Tamir Rice in Cleveland, a boy who was shot with a toy gun in a public park was at the behest of a hysterical call to the police calling them in about a black male with a gun in a public park. So too in Beaver Creek, Ohio recently with John Crawford III, a young 20-year-old who was holding a gun that was an air rifle that was on sale in the store of Walmart. And a person in that store called the police hysterically about a black male waving around a gun. So too with George Zimmerman in Sanford, Florida, who's not a police officer, who makes the same kinds of misjudgments about black maleness that we are so concerned about with the police today. So I want to say very clearly that although we are right to focus our attention on the police because of the great authority that they have, we make a mistake when we think that this is simply a problem of the police in this nation. It is not. Secondly, I want to say that we, as a result of that, a lot of the conversations that we see ourselves having here in the country right now about Ferguson and other venues are too narrow and will get us very, very little down the road that we need to get. And that is because we are arguing about the wrong things. When we talk about the police in the way in which we do, we end up inevitably engaged in a conversation about, is this a good cop or a bad cop? Is this a good cop and a bad citizen? Or is it a bad cop and a good citizen? And if you think about the conversations about Michael Brown, they devolved to that very quickly. They devolved to that in the George Zimmerman, Trayvon Martin scenario in that way as well, and they always will, because we are making a mistake when we think about this as an aspect of intentional racial animus in the way in which we would have looked at these events in years past. So the last point I want to make, because we only have a little bit of time, is a profound one. I hope you will agree. Now, at the beginning of the 20th century, W.E.B. Du Bois said famously that the problem of the 20th century was the problem of the color line. And I will say to you that the problem of the 21st century is the problem of the color blind. The problem of the color blind. The belief that somehow we as Americans can be colorblind and not see race and not have all of the meanings that are associated with race automatically triggered in our minds. That is why this is bigger than a police problem. This is an us problem. So science shows, neuroscience, decades of it now, shows that the human brain recognizes and registers race in 1/10 of a millisecond or less, faster than it registers gender. And automatically, willingly or not, involuntarily, whether we like it or not, all of the meanings that are associated with race are automatically triggered. And for black males, that can be a fatal thing in a quickly unfolding encounter. So the problem is much bigger, and Song, I know, is going to talk about some of the science behind this. But I just want to frame it that way so that we understand that these are cognitive forces that are bigger than the police, that affect all of us, but are an acute problem when it comes to officers carrying guns.
Thank you so much, Professor Davis, and a great segue to Professor Richardson. Professor Richardson, you've used critical race theory and social psychology perspectives, among other lenses, to illuminate and interrogate questions of racial violence. What are your thoughts so far?
Well, the recent killings of young black men and boys at the hands of the police are disturbing, but unfortunately unsurprising. This racial violence is, in my view, the inevitable and foreseeable consequence of current policing strategies and cultures that cause the police to question their own legitimacy and their own authority when policing communities of color. And as I'll talk about next, When officers feel insecure, racial violence is often the result. Now, I'm not saying that unconscious racial bias and conscious racial animus are irrelevant to racial violence. They're not, and Professor Davies just discussed some of the unconscious racial bias literature. However, the psychological study of human aggression suggests that it's not just unconscious and conscious racial bias that causes this violence, but that it's also personal insecurities, such as stereotype threat and masculinity threat, that can be good predictors of racial violence. So I want to spend just a little bit of my time discussing both of those concepts. So stereotype threat, as many of you may know, refers to the fear of confirming or being evaluated in terms of a negative stereotype about one's group. So for instance, we all know of the stereotype that women are bad at math. So if you're a woman and you're asked to take a math test, you may be concerned that if you perform poorly, people will attribute your poor performance to the fact that you're a woman. And so this anxiety, this stereotype threat, causes physical and mental reactions that are difficult, if not impossible, to volitionally control. Things like increased heart rate, fidgeting, being unable to think clearly. Just think about the physical and mental reactions that you may suffer from when you're anxious or nervous. And unfortunately, suffering from this stereotype threat can take mental energy away, and as a result, you might actually confirm the stereotype that you were worried about in the first place. And researchers conclude that this stereotype threat often affects those who don't fit the stereotype because this increases one's anxiety. So Phil Goff, he's a social psychologist, he's done some cutting-edge work on the police and the effects of stereotype threat on their behavior, and what he found is that one of the stereotypes that the police are concerned about confirming is that they're racist. And what he found in his research with officers, actual officers in police departments, was that officers who were high in stereotype threat, in other words, officers who feared being perceived as racist, those officers ended up shooting black suspects more often than suspects of other races, both in the lab and in the real world. What he did is he compared officers' stereotype threat score, how worried they were of appearing racist, with their actual use of force history in the field, and he found that he could predict whether or not officers had used force against young black men, actually used force in the field, based on how worried they were about appearing racist. And there was surprisingly no connection between conscious racial bias and unconscious racial bias and the use of force against black men. It was stereotype threat that predicted it. In fact, officers who were high in stereotype threat were more likely to have used force against black suspects in the street than actual explicitly, consciously racist officers were, officers who admitted to being racist. I want to talk very briefly about masculinity threats. I know I'm almost out of time, and then I will end. So masculinity threat refers to the fear of being judged as insufficiently masculine, as insufficiently manly. And what Goff found was that officers who were high in masculinity threat, again, these officers were more likely to use force against young black men, both in the field and in computer simulations. And once again, there was no association, at least with these police departments, with unconscious and conscious racial bias and the use of force. But masculinity threat did predict the use of force in the street. So what are some of the implications then of this discussion? Well, first, it can help us to understand why racial violence is both inevitable and over-determined, even in the absence of both conscious and unconscious racial bias. So for instance, a number of policing practices, such as stops and frisks, they make black men more vulnerable to police violence, but not in the way that we traditionally understand that. They one of the reasons they make black men more vulnerable to racial violence is because these types of practices sustain the stereotype that officers are racist, and it's fear of confirming this stereotype that can lead to racial violence. Additionally, police departments remain sites of hyper-masculinity, and by that I mean these are sites where exaggerated displays of physical strength and aggression are rewarded and reinforced and encouraged, in fact, as a way of performing one's masculine identity when it's under threat. So this then setting within police departments can place young black men at greater risk of racial violence because young black men, as we know, are stereotyped both consciously and unconsciously as being more masculine than men of other racial groups. So you can imagine then, for a police officer on the street, a young black man likely poses the greatest threat to an officer's masculinity, especially if they're non-compliant or disrespectful. And in hypermasculinity and hypermasculine settings, violence is a recognized way of performing one's masculine identity, of proving one's masculine identity when it's perceived to be under threat. So in conclusion then, I believe that we have to completely transform current policing practices and cultures that continue to produce racial violence, and until we do so, we can expect this racial violence to continue unabated. Thank you.
Thank you very much. Next, we'll turn to Professor Carbado. Professor Carbado, you have been thinking about a model to explain the role that law plays in perpetuating police violence against black men. Tell us more about the model you're developing.
Thank you very much, Linda. I'm delighted to be here and have already benefited from the panelists thus far. So what I thought I might do in the limited time that I have is articulate a model that identifies some of the causes of police violence, and I do mean to underscore the some in that articulation because I'm not purporting to present a total theory of what causes police violence. That would be very presumptuous indeed, but I hope that the model I will present will resonate you as identifying some of the factors that are relevant to the ongoing problem of police violence in American society. So I have one slide, let me put it up. So I'll just walk very quickly through the model in a conclusory way, and we can talk about any aspect of it in the Q&A if you like. So there are basically 5 features that constitute the model. Some of them are less controversial than others. So the first is basically the idea that explicit and implicit biases of African American men as violent and dangerous and criminal produces police violence, which is to say, to the extent that police officers engage these men based on that assumption, then clearly that is going to lead to police violence. The second dimension of the model describes a convergence effect, and more specifically, 4 variables converge to render black men vulnerable to repeated police interactions. So one of these variables is, again, explicit and implicit biases, which make African American men attractive to police officers in an investigatory sense. Another important variable is background racial segregation, which concentrates black people in particular neighborhoods that are always already perceived to be in need of law and order maintenance. A third variable is hypercriminalization, and this is a point that Paul referred to, which is the criminalization of just about everything, which means that it's easy to be a lawbreaker within those particular domains. And the fourth variable, which Paul also alluded to, is Fourth Amendment law, which ostensibly is a constitutional constraint on police investigatory practices, but on the ground operates as a legal mechanism, and I want to underscore legal mechanism through which police officers can engage in racial profiling. In a forthcoming paper, I'm describing precisely the way in which Fourth Amendment law expressly permits and otherwise enables racial profile. So the point is that these 4 variables converge to render black men vulnerable to repeated police interactions. The third feature of the model identifies the violence-producing effects of black men's repeated interactions with the police. So one is just the overexposure effect, meaning the greater your exposure to police interactions, the greater your exposure to police violence. One can put this point more strongly to suggest that black men's repeated presence before the police puts them in the range of police fire and renders them highly salient as targets. Another effect is the incarceration effect. So black men's repeated interactions with the police compounds their incarceration rates. The mass incarceration of black men means that when police officers interact with them, they often do so on the assumption that these men have had some carceral experience, and that particular understanding means that they're likely to engage black men more aggressively than they might otherwise do so. The stereotype entrenchment effect is simply the idea that every time black men are stopped, and this is a point that Song made as well, blackness is reestablished or rearticulated as a criminalized identity, as a dangerous identity, as an identity that must be in need of some kind of law enforcement discipline. Identity devaluation. We know that post-Ferguson there are these discourses about Black Lives Matter. Significantly, that particular observation is not just about what happens to black people when they die. It's about the terms upon which they are forced to live. And police interactions, repeated police interactions, is a way in which black male identity is spoiled, is devalued, and police officers are less likely to exercise care vis-a-vis an identity that we do not much regard. Resistance to authority. So to the extent that you're constantly exposed to the police, at some particular moment you're likely to push back, verbally or otherwise, and that too can generate police violence. So what I'm suggesting is that ordinary police interactions, repeated ordinary police interactions, can be the precursors to extraordinary police violence. And you can see that in Ferguson if you pay attention to the extent to which black men in Ferguson were, if you like, under the constant supervision of the police. So we should be focusing not just on the back-end problem of violence as it occurs, but the front-end problem of police access to black men. The fourth variable in the model, it refers to what Sung described, which is both police culture and officer self-threats. I won't say anything more about that. I think Sung's explication reveals the extent to which both police culture and police vulnerabilities vis-a-vis masculinity and other kind of threats might lead to police violence. The final dimension of the model articulates a dynamic that occurs after police violence happens. So that is to say, law interacts with police violence to translate it into justifiable force. And there are a number of ways in which we might think about that. One, a prosecutor might decide not to bring a case. That is a legal conclusion that the violence is justifiable. Or a prosecutor might bring a case and a grand jury might not indict. That is a similar translation of violence into justifiable force. Or the grand jury might issue an indictment and a jury might not convict. That too is a conclusion that violence is justifiable force. This is significant because the legal translation of violence into justifiable force diminishes the risks police officers assume when they engage in violence, which is to say, it creates a disincentive for police officers to exercise care to the extent that they know on the back end that they're not going to be held legally accountable. So I don't mean to suggest that this is a total theory account again of the causes of police violence, but I do think that these factors are at play, and it helps us then think about what some of the solutions might need to be. One more point and then I will stop. Crucially, law is playing both a role at the front end, Fourth Amendment law, facilitating police access to black men, and on the back end, legitimizing violence against black men when it occurs. So law is constitutive throughout this model in ways that I think we need to be mindful of. I'll stop there.
Thank you, Professor Carbado. Your remarks are a perfect segue into the part of the discussion involving remedies. And we're next going to hear from Professor Anderson, who, among other things, will talk about how the Supreme Court has addressed the question of accountability for deadly force.
Good morning. I appreciate oh, I'm sorry.
Thank you.
Good morning. I thank you all for being here this morning. I appreciate Professor Greene for convening this fine panel. You know, law professors should never stop learning, and there's certainly a lot of food for thought today on this very important issue. With the brief time that I have, I want to talk about what I think is a long-standing hostility of the Supreme Court toward the balance of power between citizens and police. First of all, this is nothing new, and it did not necessarily begin isolated to a racial framework. Of course, the racial framework of this country sort of begins with pre-slavery, persons of color not having legal status to even participate in the traditional criminal justice system. So if you're going to do the history of the legal structure, it would probably be post-Reconstruction and forward. So the Supreme Court started out, been the 100-year anniversary about of the Weeks case, which begins to ask whether or not police misconduct can be protected in a structural legal way. And the court struggled to begin to say, well, sometimes maybe it loses some of its protection. It wasn't until 1949 in Wolf versus Colorado that we even recognized that the states were accountable fundamentally to protect the search and seizure rights of citizens, white or black. It wasn't until the early 60s in the Warren Court that we recognized there was any remedy for this. And still, between 1949 and 1963, there was a struggle in the court, largely started by a discussion with Justice Frankfurter about whether or not the remedy should be exclusion of evidence obtained in a search or a sanction of civil litigation for purposes of police accountability. We have still struggled, and even in the most recent terms of the Supreme Court struggled with whether or not we're going to remove the veil of protection on police, which is almost an automatic safeguard against any financial or structural accountability for their misbehavior. And so in the recent term of court, particularly in an opinion, Plumoff versus Ricard, in an opinion by Justice Alito. Now, he had plenty of company on this opinion. I'm not going to just sort of put it on him, but I will use his words. Quote, if police are justified in firing at a suspect in order to end a severe threat to public safety, the officer need not stop shooting until the threat is ended. I think I don't need to read 6 opinions for you to understand that I can keep shooting till the threat stops. Much of this ties directly into some of what we've heard today, Professor Song, Professor Davies, Professor Carbado. What is the perception of the threat? The very definition that Justice Alito uses contemplates that someone, largely a police officer not accountable under legal structures of protection, gets to determine the definition of what is a threat. So you have structural problems in your definition to start with. I also would like to say that the contemporary police officer, and this is where I think one of the solutions I'm going to focus on is training, or an assumption that training should be done even if it hasn't been shown that training necessarily helps. We have many police officers, men and women, who have really grown up in the digital era, the video game era. I wonder when I contemplate some of these tragedies, and I often say, are these officers living inside a video game? I mean, think about it. The law says you can shoot till you stop the threat. The perception of the officer is based upon their perception of reality of what is the threat. At some point, I don't know who's going to do it, maybe local police agencies, maybe the state, maybe at some point a federal lawsuit will come in to play and require the kind of training that does 2 things. Number one, the officers that hold the power are told, this is not a video game, this is real. The people don't come back when you shoot. What should be the rules? Of course, with the Supreme Court saying you can shoot till the threat stops, we need some definition of what is perceived to be the threat, and some of these other speakers have addressed that. I would say that one of the things that we need to think about is this doctrine of qualified immunity, which goes along with protecting the police. You know, the Supreme Court has said often in cases, to paraphrase, everybody has to agree that the thing is stupid, that nobody would agree that it's not in order for the law to do anything about it. That's how I see the definition of qualified immunity. That is, no police officer anywhere would have believed that you should do this before a court will take action to say that there can be financial accountability. Well, obviously, there's a great deal of conflict about whether or not that is a standard that protects citizens. I don't think it protects citizens very much. I understand police have a difficult job to do and that there are legitimate, real threats. But the structural protections for citizens interacting with police are going to continue to create this kind of friction. There's a number of cases that involve police getting anonymous calls about certain gang activity, for example, and they're responding to that call by busting into the back door of somebody's or backyard of somebody's house, causing great injury. And the court's saying, well, nobody's agreed that that's in violation of the Fourth Amendment. Until all the courts agree, we don't have a reason to address the immunity question. Again, these approaches to police accountability have to be comprehensive, extensive, multi-branch. There has to be a judicial response, a legislative response, and most importantly, a community response. One of the solutions is one that we've already engaged in. We've seen protests, grassroots awareness. This is not a new technique. I have a picture in my collection of historical things of the legendary Charles Hamilton Houston in a protest with Howard University students walking down the middle of Northwest DC, all with nooses around their neck to make the point. It took decades to come to fruition some of the motivation of grassroots protests to bring people into accountability. But I think it's worth the effort, and it takes as long as it will take to get reform, whether that be grand jury reform, whether that be training reform, whether that be reform of the legal standards or legislative control put into place. If the citizens press their local governments to say, this is unacceptable to make the community safe, white, black, rich, poor, then politicians will respond by taking the matter seriously. We have a lot of impediments to taking the matter seriously. The court decisions, the legislative non-response, and most importantly, I think some of our malaise about just simply, do we think it's time to press for change? This could be a watershed moment. This could be a transformational moment. The time is now to seize the moment so that we can all have a secure and safe society. Thank you.
Thank you, Professor Anderson. As I've interacted with the panelists since we conceived the program, I've thought a lot about this problem, and I thought about this from the perspective of our treatment of endangered species for the purpose of improving their lives with treatment and also for the purpose of studying them. We have technological and also pharmacological approaches to temporarily incapacitating the most dangerous animals on the planet, whether they be lions, tigers, rhinoceri, etc. We have methods that we use to temporarily disable those animals, to track them and to study them. And a larger part of the problem that our panelists are addressing is the very assumption that deadly force is a paradigm within which we must problematize the issue of law enforcement. And it's something to really think about even beyond the discussion of immunities or beyond the discussion of civil liabilities. But let me go on to Professor Simmons as we continue our discussion of possible solutions. Professor Simmons, you are concerned that criminal prosecution and civil litigation are not effective remedies because they don't address the fundamental culture of policing in America. Explain your perspective and your alternative proposals.
Okay, thank you. And again, I'm very happy to be here, and I've been taking notes. I've learned so much already, even being on this panel. And when I told people that, folks that I was coming to AALS to do a Ferguson panel, everybody knows what that means, because unfortunately, Ferguson has become shorthand for this problem of policing and the lack of democratic policing, I think, in our nation. So while Ferguson may have been, or the situation that unfolded there may have been surprising to some people, maybe to the majority of Americans, it's not been surprising for some segments of our society, and it's what many people have known for a long time, that Ferguson is lurking in all of our cities. I think that there are lots of police chiefs and policymakers today that are wondering, how could I prevent a tragedy from happening here, happening in my town, in my city, my police department? And unfortunately, Ferguson, what happened in Staten Island with Eric Gardner, only some of the most recent tragedies in a long line of shootings of unarmed black men and unfortunately unarmed black children. And even though, and there are many other names that may not be familiar to you, Timothy, Thomas, Oscar, Grant, those names. But I think that there has been a lot of focus on criminal responsibility for these officers that have been involved with Ferguson and with the Eric Gardner killing. And we need to hold these individual officers responsible. There's been a lot of calls for, well, let's have a special prosecutor, the grand juries, the mechanism, it didn't work there maybe as we had wanted it to, so let's have a special prosecutor to prosecute these, investigate this, have a little bit more transparency. Unfortunately, I think that some of those remedies they're backward looking. I think one of the panelists mentioned that this is, we're looking at the back end, and we need to be looking forward at how to prevent this. So even though I support a lot of those proposals, and I think it's important to hold officers criminally responsible, I think that what we really need to do is encourage a paradigmatic shift in our police culture. And we know that criminal prosecutions and civil litigation have not been effective remedies for this. So there have been a lot of cries for increased transparency, legitimacy, and I want to talk a little bit about how the structural reform of police agencies might present some promising remedies here. We've already heard a little bit about the causes of police misconduct, but we can't divorce these causes from the larger organizational context. Darren Wilson was an individual officer, but he's operating within a police culture, right? The officer in the Eric Garner case, he is operating in a larger institution. So what do we know about police organizations and police culture? There are a few different characteristics that have been talked about a little bit, but this aggressive style of policing, broken windows, what have you, but there are a lot of studies, empirical studies, that show officers believe that violence is a necessary part of their job. And we have become to believe that violence is a necessary part of a police officer's job, and that just isn't the case. You can have authority, you can keep order, maintain order in society without violence. Group loyalty, well, we know a lot of us may be familiar with the term test-aligning, right? We expect officers to kind of close ranks and maybe not be fully forthcoming in investigations. There was another, a few years ago, everybody may remember, in New Orleans, where several officers were convicted after Hurricane Katrina. In the wake of Hurricane Katrina, there was a shooting on Danziger Bridge. And those, several of those officers that were initially convicted, those have been reversed for some other reasons, but those officers, they were supervisors that came on the scene to investigate and themselves participated in the cover-up. So we have this idea of group loyalty. And finally, there is the characteristic, another troubling aspect of police culture is lax supervision and discipline. When officers engage in certain behaviors, they're unlikely to be disciplined and often have been promoted. One thing that we know is there are a very small percent, within any department, it's not all of the officers that are causing a problem. Very often, it's a very small percentage of the officers that are responsible for the majority of the complaints. If we can identify those officers, retrain them, or fire them, then we can improve that department and the legitimacy of that department. So the federal government has the pattern or practice authority where they can go into these local areas and try to encourage these types of cultural changes. There's already been an investigation initiated in Ferguson. There are a few problems when we're thinking about this type of federal intervention. It's a great idea. It's happened in several different jurisdictions, Washington, D.C. Being one of them. But what happens when the federal government leaves? And the federal government, if they've negotiated an agreement or if there's a consent decree, what happens when that consent decree is over? How are we going to sustain any reforms that may have been implemented? And a lot of those reforms go directly to aspects of police culture that I've talked about. Let's have an early warning tracking system so that we can identify these officers. Let's, if there's a problem with racial profiling, let's collect information about the race of individuals that are stopped. Let's revamp our use of force policies. These are all of the things that the federal government has mandated in several jurisdictions. But the problem is what happens when the federal government leaves. And finally, even though these reforms are great in many ways, the federal government has limited resources. They can't necessarily go into every local jurisdiction that might need this type of reform. So as far as concrete solutions, and I know that my time is short, I'll say that I think that each state should have an analogous statute, right? An analogous federal statute. Each state attorney general should have the same power that the federal attorney general has in terms of changing the culture of those police departments. Also, the federal government gives billions and has given billions of dollars to local police departments under the COPS program, community-oriented policing. However, there's widespread disagreement about what does community policing mean, what are the parameters of that, and I think that one of the things that the federal government needs to do, a lot of people may think that this happens, they need to tie that funding to reducing excessive uses of force within these local police departments. And so those are just a couple of concrete things. Thank you.
Thank you, thank you. We'll turn next to Justice Reynoso, who has not only been a justice of the California Supreme Court, but also a lawyer on the ground addressing these problems in the context of California. Justice Reynoso, what is your perspective on the role of the judiciary and on the possibility of redress in the courts?
Yes, thank you very much. I received a call one time from a representative of the judicial section of the American Bar Association. And I was told that they were very concerned that the judiciary and the Justice Department in general, the justice system in general, had a very poor reputation, let's put it that way, among minority youth. But when they started investigating, they found that, in fact, that lack of trust in the judicial system and in the administration of justice system started with the youth coming in contact with the police. And so he wondered whether I could participate in a program in San Francisco relating to that. Unfortunately, I could not, but it just reminded me of how important these issues that have to do with the police have to do generally with the administration of justice and the role of judges. And the role of judges is more limited, but nonetheless important. In many jurisdictions, judges appoint the members of the grand jury. Judges are sophisticated in terms of the issues that we've been discussing here, but are very reluctant, very often reluctant to speak to those issues because they're controversial, many of them. But in fact, judges are permitted ethically to speak to any issue pertaining to the administration of justice, even if controversial. And when they appoint those members of the grand jury, they can bring these matters to their attention and in fact have them investigate whether too many people are being stopped. In my own county of Yolo County, California, the killing there took place of a young Mexican-American farm worker. He had immigrated 10 years ago and had been stopped over 15 times by the police, one time while riding a bicycle on the wrong side of the street. Why? To question him, to see if he had done anything wrong. I asked my wife, who's 80 years old, has been driving for 60 years, how often she had been stopped. She's white. She said, I don't remember, maybe once or twice. So somehow there's a disproportionate number of stops of minorities. Judges know that, and they can bring that to the attention of the grand jury and indeed of the public when they speak to community groups and so on. And sad to say, they very often do not. So there is a role for judges to play, even though in many ways it's a secondary, but I think important role. The reality is that too many young people, African Americans and others, I'm just reading the transcript of a new book that's coming out on these types of issues pertaining to the Latino community. And sad to say, very often exactly the same issues come up. This young Mexican-American farm worker who was shot in the back by the police, nonetheless, the DA took a different route, but with the same conclusion as other district attorneys. He wasn't required to, but he wrote a report on the killing. Then sent the report to the Attorney General and one of the federal agencies saying, did we do right? Well, in his report, he ignored many of the facts that raised questions about what the police had done and ignored some witnesses and was clearly written in such a way as to show that the police did nothing wrong. So the AG sends out a message saying, we can't say on the basis of your report that you abused your discretion. He sends out a press release saying, we've been cleared. You know, so he used a different technique, but exactly the same result as we had in Ferguson. So what do we need? What the families and the community are entitled to know is exactly what happened in that killing. In Yolo County, as in Ferguson, we've got more questions than answers in terms of what the DAs did, doing everything behind closed doors. I had an experience as a young lawyer when I was practicing law in El Centro, California, of a young Latino who was killed by a cop, by a white officer. There, however, the hearing about the killing took place in public. The coroner decided that he wanted to have the hearing in public. I asked to participate in the hearing. He permitted me. And so I was able to cross-examine everybody, including the cop who did the killing. That was a small community. I knew the cop. He was really a fine young man. But there the killing took place in a way where he ignored some pretty basic matters. They asked this young man to stand by the police car and not run away because they had to make another arrest. He ran away. He ran into an alley. Then he ran into a sub-alley that normally had a light in it, but it happened to be out that night, so it was dark. His fellow officers came by the alley, and he was just a few feet away and did not call for backup. And so I think he was young and wanted to show that he could make the arrest himself. There was a struggle. The young Chicano got killed. But the reality is that, and the Latino community was up in arms, as you might imagine, as they were also in Yolo County. But once hearing what happened, the family that hired me became convinced that it was a stupid killing, if you will, but it wasn't a racially based killing. And they decided to not sue the city because of that killing. And the Latino community, knowing exactly what had happened, even though, again, it was a terrible killing. The young officer should have called for backup. He didn't, but they concluded it was not a racially based killing, and the community settled down. So what we really need is to have people know exactly what happened. One of the suggestions, of course, has been that a third party do the investigation, that local DAs are too close to the police to expect an unbiased kill and unbiased report. So the suggestion's been made that it has to be an outside group, maybe from the Attorney General's office, state or federal, but an outside group. But then there's another problem I just want to mention to you, and that is that we put on too much authority, too much of an obligation on local police. So we had another killing recently in a neighboring town of a young veteran who had serious mental problems. And there, the police shot him, and they claimed that he was threatening them. Controversy by those who are there, whether they were threatened or not. And the police invariably say, "We were scared. That's why we fired." But there's a real problem with that. I was the chair of a group that was appointed by the president of the University of California to do a study in what got to be known as the pepper spray incident at the University of California, where officers pepper sprayed some students without justification in our conclusion. And I met with many experts. One expert told me that he was the type of expert who gets hired by the police to go and do an evaluation. He had been hired between 50 and 60 police departments. Of those, he said, only one met the standards he thought all of them should have. And the standard they didn't meet was that they should treat everybody equally, a fellow officer or a non-fellow officer. In other words, he was saying in all of them but one, the officers protect one another, even when they violated the law, because the sense of the blue uniform that causes them to protect one another. So long as that's true, it'll be very difficult to find out exactly what happened. But then, as I say, sometimes they're asked to do too much. The officers in that community near where I live, when they saw that the young person was, in fact, they were told by the family that he had serious mental problems based on his war experience. Actually, we should afford other agencies. They should have called an agency that deals with those who are mentally retarded. We have so many arrests of drugs. Most experts say that the excessive use of drugs is a medical problem, not a police problem, yet it's the police who deal with that. Domestic violence, how many killings take place during domestic violence? There are experts who know about domestic violence. They should be called rather than the police. So in some ways, the police are expected to do too much, but in another way, they're so protective and there's so little, as indicated, danger to them because of what the Supreme Court has said and because of the protection by the local DAs that they can do these things with impunity, and I think they know it. Therefore, they say we're scared. In the situation at UC Davis, the officers all said they were scared. When we did an investigation, we found that they were never surrounded as they said they were. There was no reason to be scared, but they claimed to be scared. That's my report.
Justice Reynoso of the California Supreme Court makes me proud to be a member of the California Bar, for sure. We're going to turn now to John Burris, who joins us from Oakland, California. John, you've used civil rights lawsuits as a tool to seek systematic structural change and to address wrongful detention, excessive force, and other civil rights violations. What have you done and what results have you reached?
Thank you. It's good to be on the program, especially hearing Justice Reynoso, who has always been a beacon of light for us in California. I won't say he was doing this way before I started law school, but it's true. He was but let me say this. I have listened to everyone here, and much of what has been said are the kind of ideas that are sort of dancing around in my head all the time as I am practicing law. In my office, at any point in time, I could have 10 to 15 police shootings there, mostly shootings of African-American men and brown people, but some occasionally there are white men who have been killed as well. Those circumstances are somewhat different, but at the end of the day, you have to look at every one of these cases and to really get some sense about what was the police officer thinking. Now, part of this whole process is understanding the tools that you have, okay? And we all, not all of you may know, but you know, Graham versus Connors is the leading case on use of excessive force, and the city of New York versus Monell is the leading case for sort of pattern and practice that can be utilized. And so, having looked at police departments around the state, I have focused mainly on Oakland as sort of an incubator to try to bring about reforms. And so in 2000, we were able to get a case where I represented, me and another lawyer, 120 people who were systematically abused by the police. And what came out of that was a negotiated settlement agreement, comparably referred to as a consent decree. And what that did was allow us to look at all aspects of the department, to sort of rewrite policies, to implement those policies, and to sort of change, if possible, the culture of the department and certainly how they do business. And unfortunately, we've been involved in this case still since 2000. We have not completed the process. It takes a very long time. But what has happened even over the last 3 years is we're starting to see some successes in this. The shootings that were pretty rampant in Oakland are down. We only had one in the last 2 years. The stops and acts of brutality are down. And it's really a consequence of the monitoring that was taking place. We had an independent monitor. We had a federal judge that was involved. Much of what the Justice Department has tried to do, we in fact did it as private counsel, and has been relatively successful. I would only say this, that it can only be successful in terms of reforms in a particular department if there's a commitment on the part of the leadership of the city as well as within the department itself, because police departments and police officers are totally resistant to change. And to the extent that someone like myself or other are coming in and trying to impose a different standard, even if it's the best practices, they are unwilling to change. And that has been the most difficult challenge we have had in trying to move the department in a more different direction. Now, I would say that in terms of the impact on, the most important impact to me in terms of analyzing where this data go, what happens here is on the stop data that we had, where officers have to identify who they stopped, why they stopped them, what ethnic backgrounds of the people, what kind of searches, if any, that took place. And we all talk about racial profiling, but I think the racial profiling kinds of stops really can lead to these deadly shooting encounters, where a very minor event, lawful or not, in terms of a stop, given the reaction of people to that stop, can result in the use of deadly force. And part of what I've always concerned about is how can a minor traffic event, why should a minor traffic event wind up in the use of deadly force? And that's really a function of the attitudes of the officers who are involved, their unwillingness to de-escalate a situation, but to demonstrate the influence and power that they have. But in terms of getting back to it, I have sent many cases to the Department of Justice for prosecution, many to the District Attorney's Office. Only one has come back in 20-something years for a prosecution in the state system, and that was the Oscar Grant case, which some of you may know from the Fruitvale Station movie. I was in the Rodney King case as a trial lawyer, but that was only after the criminal prosecution had taken place. Each one of those cases, of course, had video cameras. Since Michael Brown case has taken place, I've had 7 police shootings. None of the people were armed, and there's only one video camera that's involved. But even with those cases, as I sent to the district attorney's office or the U.S. attorney's office, nothing has frankly happened. So I don't view those as viable options in terms of impacting and causing reform within a department itself. The Department of Justice can, or they could do something in Ferguson, but it is something that the police agency itself has to be involved in. I would only say in terms of the biggest impediment to all of this, in my own mind, is the police association unions. These are very powerful institutions within a city, and if there's any complaint, any way that I would have altered my approach in bringing about the reforms in Oakland, is I probably would have involved the police union leadership earlier, because you need the police union buy-in and you need the community buy-in. You need people to understand what you're trying to get done from the police association point of view, the ordinary cop on the street, as well as the community people, so that there's some association. But I will say that some of the stuff that is taking place now in terms of shoot, don't shoot situations, looking at some of the racial questions, the implicit bias that we're looking at through Professor Eberhardt in Oakland, I think ultimately will have a real benefit. The most important thing is the shootings are clearly down and the beatings are down. And so we've had some positive impact. I'm looking at other cities to see, particularly where I see large numbers of shootings, like down in the Central Valley and some of these other cities, that I think that you can do certain things. It's not a panacea as to how you can change the attitudes of police officers, but as has been said, qualified immunity is a huge issue, and it's one that you have to overcome by, expert testimony and witnesses, et cetera. So it can be done. I've had many cases where we made some real efforts in this regard, but at the same time, the challenge is in front of you, because all you have to do is look at Ferguson and look at New York City. You will see that that challenge can be transposed all throughout the country, and certainly in any urban area. Okay?
Thank you so much, John. We have 15 minutes for comments and for questions. And if you have a question or a comment, would you please come to one of the microphones? There are 3 microphones. It would be great to see how many people wish to speak so that I can manage the time. Yes, go ahead. Say your name, please.
Len Pertnoy. I'm a tenured professor at St. Thomas Law School, practiced for 42 years, inner city of Philadelphia. Want to acknowledge that you were able to probably illuminate so many areas of what we're all concerned about, every one of which could form a course at the university for sure and be very worthwhile. I want to limit my comments because there's many other people, but so much of what I've heard has always been identifying the problems. We hear about, we want culture, we want interaction. A lot of what you say is us against them. Well, how do we really get to solving the problem? And the problem, as I see it delineated here, which is your subject, basically deals with the discrimination toward our black citizens, and I agree entirely. I don't think it's debatable in reference to what you put out scholastically, okay? However, it's just the disproportionate of a much larger problem which exists between police and all citizens, including myself. If I get stopped by a police officer just for a parking ticket, I'll ask him a very simple question like, what did I do? He'll say, keep your mouth shut, stay in the car until I speak to you. And as soon as he does that, we're in conflict. Now, how do you change that? That's what I've been concerned about, and you talk about culture. You can only look to what's really working in some of the neighborhoods. And some of the things that I see that do work. My son got involved in Syracuse where they had gang problems. And what they did was start a program where the police formed a baseball team that played against the gang teams. And little by little, instead of becoming police and citizens, they became people. And they recognized what those people were. In New York, when I used to go there, where there was constant conflict, the last time I was there, they had police officers giving ice cream cones to kids. Okay? If we keep a militarized impression of the police being a formidable force instead of being part of us, that we all want to work together in reference to resolve, we're not going to get anywhere with these problems, because we were formed as a violent country. We are a violent country. There's 300 million guns out there. And what happens with these problems, in every one of the things that you've articulated, which I agree with, are seminal events. But unfortunately, those seminal events, 3 months from now, will be on the comic pages in America because they'll be long gone. And the changes don't occur in court. They don't occur in the Supreme Court. Change, in my opinion, will only occur from the bottom up, and then everything will be reflected accordingly. And we need to send people on a regular, oncoming basis down to the lowest levels of our society, where the police go into these neighborhoods, have discussions, are on the street, and become people. And long as they wear flak jackets, and long as you bring back all the materials from war and put them in tanks and guns, we're never going to have any kind of dialogue, because it's always going to be us against them. And we need to become us and us as a country. And that can only occur, in my opinion, from the bottom up. And I'd be interested to hear your response in reference to that. Thank you so much for allowing me.
You've very well illuminated an overarching issue, this question of the role of the community and the very social contract, the fundamentals of the social contract involving the community and law enforcement. And any comments? Yes. Professor Anderson, Professor Burris?
As part of our reform efforts in Oakland, we had a community outreach aspect of it, and there is regular meetings taking place between police officers and community people to discuss, one, what the job of the police officer and why it is what it is, and to get the people to understand what the challenges are in policing. And that, in fact, is working. Now, the problem with it, of course, you can have these community meetings, but then next week you go out, another police officers go out and they harass the very people that they've been talking to. So you have this contradiction. And so until everyone gets on the same page, not only the talking and the interaction, but then the policing by other officers, you will undermine the efforts that are being made. But I agree with you in terms of the community activity that has to take place with the police.
Professor Anderson, Professor Reynoso. Professor Anderson first, and
Yeah,
then
since
Justice Reynoso.
Since Ferguson, many polls have been taken already, showing that in some ways we have two Americas. The concern that African Americans and the minorities have of the police is very high. The concern that non-minorities have is very low. So, for example, when there are killings by the police and there's a trial, very often the police are acquitted because the jury is composed principally of people who haven't had problems with the police, who don't believe the police would lie under oath, and they acquit them. So in some ways, sad to say, that's the reality in America, and America needs to know the reality of what's happening in those police shootings, I believe.
Thank you. Sure, please.
Very profound question. Community-based contact with police is probably the way to permanent solution. I've been involved in training police officers in Baltimore City. There's one thing I've learned about police. They will do what you tell them to do until you tell them to do something different. Actually, they are quite amenable to training. The street level officers on the day-to-day decision-making process are amenable to training, but I think a lot of the training needs to take place is with the mid-level supervisors, you know, the sergeants who are supervising groups of police. You know, you cannot go where you do not walk, you know, you cannot teach what you do not know. I mean, how do these sergeants and the mid-level supervisory staff train their officers? I think a big dedication of training should be to that group, because it used to be that the officer on the beat, whatever color they were, knew the people, knew where the kids went to school, knew about their football games, knew who had a propensity to start arsons and to break into houses, and they could address these things because they had better contact on the ground. We have to return to a spirit of community, that the police work for the community, not the community is subject to the militarization of police forces. And I think they would be willing to have a different model. We have to put the resources to making that happen, as opposed to complaining about what's not taking place.
We have three at the microphone in the middle. Sir, state your name and your question or comment, and then let me also get the comment of the lady behind you so that we can be sure to get more voices from the audience. Thank you so much.
Yes. Well, it's well,
Let me, John, if you don't mind, I want to get two questions on the table so we can hear all the voices. Thank you. Can't hear anything. Go ahead. Yeah.
In America, and thank you. Sorry, I'll just restate it. Sahar Aziz from Texas A&M School of Law. My question relates to what we can do as law professors and how we can leverage our positions in law schools, particularly with the students. Because my observation and my discussions with other law professors at some other schools is the world was happening while the law school was just silent. And we weren't having conversations within the law schools and having debates and making sure that our students, the next generation, is engaged and is being informed so that they can go out there and work with the police departments and work with the communities and be the community organizers and activists. So, and I highlight that because I went abroad right afterwards, and you're correct, Dean Levitt. The entire world is talking about it, and yet it feels as if our law schools are not. And so there's this huge contradiction as if we're living in these two parallel worlds vis-a-vis the law schools, which is where justice is supposed to be taught, and the real world. So I'm curious to know what you all think we can do as law professors to engage our students to be kind of the change of future, the future of change.
Professor, I want to call you Professor Burris. Mr. Burris,
I've
talk
been
about
called
those
worse.
police
Okay.
statistics, and then we'll throw the larger question out from the professor
Yeah, I think-
at A&M.
Yeah, gathering statistical data is important if you want to prove a pattern in practice. One of the deliberate indifference is under the Monell theory of law. And in order to do that, I generally will have a case, a shooting case, and then I try to gather the data within that particular department or that county agency to determine if I can see a pattern that exists, particularly where all the cases have been vindicated on the part of the police. And to show that the officers then have feel impunity because every case they're going to get supported no matter what. Now, gathering data is something that takes a little bit of time to do. I have to know something about the department, but I do try to get it. Now, some departments there's inadequate data, and so that's not one that you can do much. If there's only been 1 or 2 shootings, I don't look at those cases as potential. But over a period of time, you will see. There are cities that have a large number of shootings, like for example right now in Sacramento, as a number. I've had a number of shootings up there, as well as Sacramento County and Alameda County. So I kind of look to see what I can do because the greater effort can be made if you can make the department understand and appreciate that you have a large number of shootings here, and if the court rules that there is a pattern in practice of Monell theory, it's going to cost them a great deal of money. But the more important part about it is you're in a position to do injunctive relief. I was very fortunate in the case that I have to rewrite the overall policies themselves, me and other lawyers and with police people. So the opportunity to do good work in a practical sense can occur if you can show from the statistical data that there's a high incidence of shootings. I've also asked the Department of Justice to come in on cases like that, certainly down in Salinas, California, where four Mexicans have been shot recently within the past 9 months, to take a look at those cases. So data is important. statistical data is important to gather. Sometimes it's difficult to get, but it is something that you try to get.
Let's have a couple of responses to the question of what law professors can do.
Well, and this, and my comment speaks to, I think, both. So what Professor Wright was talking about in terms of the second part of your question about the lack of statistical data, of course, we all know that there's no comprehensive database on police shootings. You can go there are lots of what we call crowdsourcing, right? Independent researchers and practitioners that are trying to gather this information. There's been several efforts historically for the Department of Justice, for the government, to gather this type of information, and there's now a bill, I think it was introduced in October, to begin collecting this information, because as for practitioners, you shouldn't have to go out and independently seek this information county by county. As I was saying earlier, the federal government gives lots of money to these local police departments, but does not require much of them in terms of collecting the statistical data. It shouldn't only be police shootings that we're thinking about, or deaths. It should be all types of uses, of serious uses of force that we should be collecting information on, because you can fire your weapon, but you can miss, or you can fire your weapon and that person might live. So we need to collect all that information, and to also think about what can law professors do if we have this national database from these 17,000 local police departments. Law professors, university professors, we can begin the very important work of empirically studying these incidents. And that information is so important because it not only tells us, not only gives us the opportunity to develop, to see if there's a pattern or practice of excessive uses of force, but it can help to identify areas for training. In what circumstances are police officers most likely to use their service weapons or pepper spray or whatever it is. So I think that establishing a database is important, and I think that as for law professors, we can utilize those law students to look at that information and develop some policies.
Because we just have 5 more minutes, I want to get the questions and comments from those who are at the microphone. I want to hear the questions, all 4 of you, so that at least we can hear your questions and comments and continue to discuss them perhaps after the panel disbands. Please state your name.
My name is Sunita Patel, and I recently joined the team at American University Washington College of Law, but prior to that, I was a litigator in New York and litigated the stop and frisk case against the NYPD. And so I'm so excited to see this panel and to hear from so many people who I've admired and drawn on your work for many years, and just wanted to throw out one or two other things and then ask a accountability framing question. And the first is that someone mentioned discipline of officers, and I think when we talk about discipline of officers, we need to think about who's doing the investigation of complaints and who's making the decision about what the consequences will be for investigations or complaints that are founded. So whether it's through the civilian complaint review process or some internal process, in many cities, the decision about discipline comes back to the police force itself, the police department itself, which is, that's just backwards. So we need to be thinking about how to...
We only have 5 minutes, and I do want to hear
Okay.
the others. So
And
just a couple more comments,
sorry.
and then...
Yeah, and so then I
thank
wanted
you.
to just ask everyone if you have suggestions for other models of accountability for public institutions that we can draw from. So schools and hospitals and other public institutions are, it's common for the community to be part of accountability for those institutions, but we don't see that for police. Even in prisons in Wisconsin and other places, you have more community models of accountability. So I wondered if there are other places we can draw from within the criminal justice context and other kind of public institutions.
Great, thank you. Yes. State your name clearly.
Yeah, B.J. Jones. I teach at the University of North Dakota Law School.
All right.
I also serve as a tribal judge for several communities in the Dakotas and Minnesota. And I really want to thank Professor Butler for invoking that death penalty case, because to me that shows the fundamental problem here. People of color's lives are worth less in our criminal justice system than Anglo-Americans. This is particularly seen in the Native American community. Native American males are actually the most likely victim of police brutality and police shootings. But Native American males are also the most likely victims of crime that go unprosecuted. So how can we expect to hold our police accountable for victimization of people of color when we don't even hold our own citizens accountable for that? So I think we have a fundamental problem. We have to look at that issue Professor Butler talked about. How can we hold our criminal justice system accountable for all victimization of people of color, not just police victimization?
Excellent. Thank you.
Hi, Addie Rolnick, UNLV Law School. I've been working on these issues in the context of citizen self-defense, and I had a thought that I sort of wondered how it worked in the police context. One conclusion we might draw from everything that we've heard on the panel is that race and gender are always involved in stranger self-defense cases, whether it's police or citizens, because they're visible characteristics, and not just that, but the deck is stacked against black men, black women, Native American men, Latinos, in all of those situations. And so there's two things that we could sort of do legally. One is make the right smaller, so as narrow as possible of a right of self-defense, knowing that the deck is stacked against certain people. That might be more practical in the citizen context. I'm guessing it wouldn't get a lot of support in the police context of making that self-defense right narrow. But the second thing is we could force an explicit conversation about race. So the opposite of what the court did in the Zimmerman trial, where they said don't say racial profiling. We could force the review of the cases to talk about race explicitly in every context, and perhaps to recognize that the deck is stacked against certain people and look at the remedies that way. I don't know as much about the police context, and what I'm wondering is, does that explicit acknowledgement of race ever work in any of the contexts that you all have talked about? Does it seem like it's impossible, or might it be something that would be possible?
Thank you. And thank you. Thank you very much.
Michelle Jacobs, University of Florida.
I didn't hear.
Although I don't live there.
I'm sorry. Just say your name.
Michelle Jacobs, University of Florida. So I had a couple points that dovetails nicely with her. In the Florida cases, both Trayvon Martin and the Thug Music case, and this goes to the comment about what law professors can do also. The problem is that the prosecutors didn't understand the racial implications of the cases, which is why they didn't want to talk about race. Because the racial implication was that when we teach law, the normative value for reasonableness is that black lives don't matter. And so that was the difficulty they were having, getting to the jury to understand why it was improper for these people to kill the young black men involved. You know, in the Thug Music case, it took 2 trials for 12 people to come to the conclusion that, yes, it was inappropriate to kill somebody because you don't like their music. And then just lastly, I would tag on to the international thing, that this is actually not the first time that the international community has been effective in helping to prevent violence against black people. The Burgess case is out of Chicago, where the Chicago Police Department were torturing and killing defendants enforcing confessions, was actually pushed to the fore in combination with the community activists and the international human rights committees. And finally, the mandatory life for juveniles who were convicted of non-death penalty, non-murder cases was also forced to the fore in the United States by the International Human Rights Tribunal, so we should remember that. And the last thing for the law professors is stop teaching laws neutral and colorblind. That would go a long ways to curing some of the problem of lack of discussion.
Thank you. I want to thank all of you who came, and let's give a hand for our panel. Unfortunately, it's 10:16, and our time is up. Thank you for coming, and continue this discussion here at the AALS and back home in your work in your communities.